Good morning from Hong Kong. Welcome to the HKIAC webinar on the Belt and Road Initiative. My name is Jolio, a Deputy Secretary General of the Hong Kong International Arbitration Center. At today's webinar, you will hear presentations of different aspects of the BRI, from introduction to the initiative, relevant statistics and trends, typical BRI-related disputes submitted to the HKIAC, and practical tips for managing risks for BRI projects. I'm very pleased to welcome two speakers to join me for the discussion today. First is Professor Wang Kidani, the principal of Addis Law Group and Associate Professor of Law at the Seattle University School of Law, where he teaches international law, litigation, and immigration law. During the summer, Professor Kidani also teaches international arbitration and the dispute settlement courses at the School of Transnational Law of Peking University in Shenzhen. He publishes widely on international arbitration and dispute settlement, among many other subjects. Secondly, Ms. Maria Tan Patterson. She's a partner at Decker Hong Kong. She's a top international projects and a commercial lawyer with an extensive and a diverse background in commercial, M&A, capital markets, joint venture, and financing transactions, as well as international arbitration. She has advised on many high-profile inbound and outbound commercial and project-related transactions and has practiced in the US, Europe, and Asia Pacific. Maria is also a member of HKIAC's Belt and Road Advisory Committee. We will first hear from Professor Kidani, who will introduce BRI and provide an overview of the available dispute resolution mechanisms. I will then give a presentation on the role and experience of HKIAC in BRI disputes. Last but not least, Maria will speak about management of risks for BRI projects. During the seminar, you can use the Q&A icon on your screen to send questions to us, and we will address as many questions as we can during the Q&A session at the end. Okay, without further ado, may I first invite Professor Kidani to give his presentation. Thank you.
Hello, everyone. Good morning, good afternoon, or good evening, wherever you might be. My title is BRI, a vision, a framework, or a system. Economists have their own reckoning of what BRI is all about. But what is it for lawyers? That is one of the questions that I'd like to start with, and also talk a little bit about basic facts, and then available mechanisms of dispute settlement before I let Joe talk about HKIAC's experience with disputes that arise out of these BRI projects. The next slide that you see shows, next slide please. This shows the geographic scope of BRI. And it's conceived with a touch of historical symbolism that as I put it in the next slide. And it is designed to replicate the famous overland Silk Road economic belt, a maritime Silk Road. And it was inaugurated back in 2013 by President Xi at an ASEAN summit in Indonesia. It's massive in its scope. It includes 60% of the world's population and a third of the world trade. It encompasses Asia, parts of Europe, and Africa. The idea is to harness public-private investment in major physical and to a certain extent virtual infrastructure projects. The projects mainly focus on railways, energy pipelines, highways, ports, and many special economic zones. Next slide, please. Here's an example of a railway that has just been completed connecting Nairobi to the port of Mombasa in East Africa. And I don't have the ability to move the slides down, so the next one, yes. So one of the things that makes BRI its own initiative is principally the source of financing. So this is China's vision. And it's financed primarily by policy banks, sovereign wealth funds, state-owned banks, and now gradually, global and regional banks are getting involved. It's a combination of all of these financing of these projects that gives it a geographic and also China-centered focus, right? Now, the next slide would show what has been conceived as basically as a framework that is relying on existing mechanisms. Now, if you look at this report, it's more or less recent. The amount of money that has already been spent has exceeded $100 billion. And from 2013 to 2018, trade between and among BRI countries has actually exceeded $6 trillion. So as I said earlier, that is about 30% of world trade. So now what I want to focus about next is, on the next slide, is the vision from the very beginning is, as President Xi said on May 14, 2017, in a speech, he said, "I have said on many occasions that the pursuit of the Belt and Road Initiative is not meant to reinvent the wheel." That is the key that I want to emphasize. It is not designed to reinvent the wheel. Rather, it aims to complement the development strategies of countries involved by leveraging their comparative strengths. From an economic perspective, economists would give this their own interpretation, but for lawyers, what it means is that BRI is not a regional free trade agreement or any type of agreement that brings regions together. What it is a mechanism that actually relies on existing institutions, existing laws to a certain extent. Of course, I'll come to that. Certain modifications are being made and certain new institutions are being created, but it is essentially not meant to reinvent the wheel. It relies on existing mechanisms for its ordering and also, as I will come, for dispute resolution also. So this is a segue to what I'm going to be talking about in terms of dispute settlement in the next slide. So I'd like to start by trying to characterize the nature of possible disputes into three categories, the way I see them, and I have symbolism to describe it in the next slide. And the mechanisms of dispute settlement, the two sections, I'll discuss them independently without exceeding my time limit. So I say upstream, project, and downstream. You'll see the next image shows, this is the Three Gorge Dam, as you all know. But the symbolism is this: water comes in, generates power, and goes downstream. So the upstream, the project, and the downstream. So legal disputes could arise from upstream in the project stage or the downstream. And let's go to the next slide. This will help us. The upstream instruments are financing agreements, basically. So each one of these projects within the Belt and Road are financed, and the financing has to have all sorts of complementarities. It comes from different banks, it comes from different jurisdictions, although principally based in China. So any number of disputes could arise from these upstream documents, although disputes in that context are very, very rare and unlikely, but that's a possibility, including sovereign laws that could be defaulted, any dispute that could arise out of that, issues of sovereign immunity and things of that sort. So the project level, to make a mega project happen, as we all know, literally hundreds and thousands of agreements are signed. What makes these agreements different are mostly they are of a transnational nature, meaning they cross borders. Dispute settlement provisions are presumably contained in each one of them. Some could be implemented in specific jurisdictions, some could cross borders. And then, of course, once the project has been built, in many cases, as I tried to show in the Kenyan standard gauge rail operation, even after the project has been completed, at the operation stage, some of the financiers could have their own stakes, and other sorts of dispute could still arise. So there is the upstream issues and the project issues and the downstream issues. Let's go to the next slide. Now, how are these disputes resolved? Ordinarily, when a dispute arises in any given jurisdiction, people go to court. Now, when a dispute is of a transnational nature, there are so many different problems that could arise. Primarily, there are front-end jurisdictional problems. Having personal jurisdiction, subject matter jurisdiction, or other types of jurisdiction for each one of those courts that might be involved in these projects, that could be a problem. Each one of them could have serious implications. Even if the court may, in any jurisdiction, may have jurisdiction, there are all sorts of complaints about cultural issues, linguistic perception, all sorts of things. And then, assuming that a trial takes place and an award is made or a judgment is issued by a court of law, then there's back-end jurisdictional challenges of attachment, immunity, all sorts of other issues. Let's go to the next slide. So because of that, the preferred way of resolving transnational disputes is alternative dispute mechanisms, including conciliation, mediation. They tend to be relied on from time to time. They could be effective in a variety of contexts, but when we proceed to binding forms of dispute resolution, obviously the most important one is international arbitration. And the reason for that, obviously, is that it could be the awards could be enforced across boundaries, whether it's an investment treaty or whether it's a commercial arbitration because of the New York Convention. Now, when we come to that, of course, that's the main topic for us in commercial arbitration involving BRI projects. The quality of the agreement and the appropriateness of the forum, the appropriateness of the choice of law, and the choice of institutions and arbitrators are extremely important considerations that need to be taken into account from a drafting point of view, as well as once a dispute has arisen as to how those disputes could be resolved. Now, the next slide allows me to say a few words about what my concluding remarks are. Now, my own reckoning of this matter is that at this point, it's been since 2013, I believe that BRI is now transitioning from being a vision to a framework. And that is because if you look at this map that I showed earlier, so that's my first slide, it has a geographic focus, but it's not a regional trade area. Financing principally comes from China, and the vision itself is articulated from China. And there is similarities in the instruments that are now being used in terms of the loan instruments, the contractual instruments. Most of these projects are being carried out by Chinese enterprises, which have their own cultural heritage. So a combination of all of these things, and now the involvement of regional and international banks, give it a focus that is so important that I believe would make it look like gradually some type of framework under which projects are executed and disputes are resolved, and a particular model is being projected. Now, and as I said earlier, it doesn't intend to reinvent the wheel, at least not so far. It uses existing norms and institutions, such as arbitral institutions and to a certain extent, courts of law, existing courts of law. I believe going forward, it will probably contribute to normative development and the harmonization of rules. Helps readapt and improve existing institutions, and to a certain extent also create new ones. An example that comes to mind is the new Chinese commercial court. And with that, I would like to conclude. I might have exceeded my 10 minutes a little bit. And of course, the next discussion is about HKIAC's experience. And I think Joe will take it from here. And thank you.
Thank you very much, Professor Kidani, for your overview of the BRI, which I think sets the scene nicely for the following presentations. For my presentation, I will discuss the suitability of HKIAC for BRI disputes and also our experience in handling such disputes so far. I have set out on this slide the key reasons why HKIAC is well positioned to handle BRI disputes. In addition to its neutrality, global reputation, market-leading rules, and many other well-known attributes, I would like to just highlight 4 points which are particularly relevant to BRI disputes. First and foremost is HKIAC's status as a qualified institution under the Hong Kong Mainland China Arrangement on interim measures, and its experience in facilitating applications made to the PRC courts. The arrangement is the first and currently the only legal instrument mainland China has entered into with another jurisdiction, which allows the mainland Chinese courts to issue interim relief in support of arbitration proceedings sitting in Hong Kong. The ability to seek orders from the Chinese courts to preserve assets, evidence, and conduct is critical to protect the parties' interests in mainland China. As most BRI disputes have a Chinese element, the arrangement is highly relevant. It is important to know that if a party wishes to benefit from the arrangement, it should make sure that Hong Kong is chosen as the seat and a qualified arbitral institution such as HKIAC is chosen as the administering body. Since the arrangement came into force on 1st October 2019, HKIAC has processed 24 applications involving parties from 5 BRI jurisdictions. If you want to know further details about arrangement and HKIAC's relevant practice, you can watch the recording of an HKIAC webinar on the topic on our website. The second point I would like to make is that any HKIAC awards issued in Hong Kong are enforceable in most of the BRI jurisdictions. At present, 119 of 144 BRI jurisdictions are parties to the New York Convention. Therefore, an HKIAC award issued in Hong Kong is enforceable in 82% of all BRI jurisdictions. HKIAC awards also enjoyed a particularly strong track record of enforcement in mainland China. Since the year of 2000, the Chinese courts have only refused to enforce 3 HKIAC awards. The third point is that in October 2016, HKIAC launched an initiative that provides a free hearing space to parties to any dispute resolution proceedings in which a party is a developing state on the OECD list of official development assistance, and in which HKIAC provides any administrative support. Currently, more than 70% of BRI countries are on the OECD list and can benefit from this initiative. HKIAC not only provides physical hearing facilities, but also virtual hearing services. And we have seen a strong demand for the use of virtual hearings in our cases. Given the current global travel restrictions, if a physical hearing in any BRI jurisdiction is not feasible, parties can consider using HKIAC's virtual hearing services. And again, if you are interested in any further details about our virtual hearing services and practice, we held a HKIAC webinar in May this year, and you can watch the recording of that webinar on our website. The fourth and the final point I will make is that HKIAC is obviously known for its vast experience in handling disputes involving mainland Chinese parties. And many of those disputes submitted to HKIAC over the years concern outbound Chinese investment, and some of them are between Chinese investors and their counterparties in the BRI jurisdictions. And then now let's look at the BRI-related disputes at HKIAC in more detail. From January 2016 to June this year, HKIAC has registered a total of 980 arbitrations involving at least one party from the BRI jurisdiction. These 980 cases feature 2,055 parties and a total of 42 BRI jurisdictions. For the purposes of our statistics, BRI jurisdictions are the 144 jurisdictions identified by the Chinese government on its Belt and Road portal. Given the undefined scope of the BRI and the limited data available on the number, size, and the terms of BRI projects, identifying disputes from BRI projects is a challenging task. However, for the purpose of this presentation, I have identified 95 arbitrations involving at least one party from mainland China and one party from another BRI country that were administered by HKIAC between 1st January 2016 and the 30th June 2020. I should say that these cases represent only a fraction of all disputes submitted to HKIAC that have a BRI element, as many other such disputes arose out of transactions that were structured through offshore entities controlled by Chinese investors. Here I have set out some more specific statistics in relation to the 95 cases. As you can see from the screen, the total amount of dispute is approximately 1.8 billion US dollars. Most of our, the top three types of disputes are maritime disputes, which account for 30%, followed by international trade, 27%, and corporate disputes, 15%. Other types of disputes we have seen in our cases include professional services, finance, construction, and IP disputes. All 95 arbitrations are sitting in Hong Kong, and 75% of them are governed by the HKIAC administered arbitration rules. 17% were administered by HKIAC under the UNCITRAL rules. Parties are free to choose any governing law in HKIAC arbitrations, and the top three choices in the 95 cases were Hong Kong law, 43%, followed by PRC law, 23%, as well as English law, also 23%. Other governing laws chosen by the parties included Korean law and the New York law. 73% of the cases were conducted in English, 80% were in Chinese, 9% were in both Chinese and English. I have included two sets of statistics in relation to PRC parties. I thought they were quite interesting. Contrary to the common perception that PRC parties are usually the respondent, our statistics show that the role of the PRC parties in the 95 BRI cases were actually largely evenly divided. 42% of the cases, in 42% of our cases, the PRC party was the claimant, and in 55% of them, the PRC party was the respondent. And in 3%, both sides included a PRC party. We have also identified at least 10 cases involving a total of 9 Chinese SOEs or their affiliates. Similarly, in those cases, about half of them, in half of those cases, the Chinese SOE was the claimant, and in the other half, the Chinese SOE was the respondent. And finally, today, 32 arbitral awards have been issued in the 95 cases. This graph shows the nationality of the parties involved in the 95 cases, and it's not surprising to see that Chinese party is the top nationality. They appear in all 95 cases. And I thought what was interesting was that Singapore is the second top nationality, and the Singaporean parties appear just over half of those arbitrations. And they are followed by South Korea, Hong Kong, China, Malaysia, Thailand, and Italy. You can see the rest of the nationalities on this slide, and it's a mix of nationalities from Southeast Asia, the Middle East, and Africa. The next slide shows the nationality of the arbitrators appointed or confirmed by HKIAC. Just for the benefits of those who are not familiar with HKIAC procedures, a confirmation by HKIAC refers to a confirmation of a designation of arbitrators made by parties or co-arbitrators under the HKIAC administrative arbitration rules. And as you can see that British arbitrators received 24 appointments or confirmations in the 95 cases. And the Hong Kong arbitrators received 15 appointments and confirmations. And Malaysian arbitrators, mainland Chinese, Australian, Canadian, Singaporean arbitrators also receive a good amount of appointments and confirmations in those cases. And today, 54 arbitral tribunals have been constituted out of those 95 cases. Just to give you a closer look into HKIAC's BRI related cases, I have identified 2 cases administered by HKIAC that have a strong BRI connection. Each case involves a dispute concerning a transaction connected to a BRI country between a mainland Chinese party or its affiliate on the one hand and its counterparty in the BRI country on the other hand. The first case concerns works contracted to a Chinese SOE to install submarine power cables in respect of an oil field in the Middle East. The claimant was a joint venture established by a Chinese SOE and a UK marine engineering service provider. The first respondent was a Chinese company controlled by another Chinese SOE, and the second respondent was a wholly owned subsidiary of the first respondent in Saudi Arabia. The dispute concerned largely the alleged failure by the respondents to lay an electricity cable at a level required by 2 contracts between the parties, and the alleged breach of contract by the claimant in relation to the alleged defects in its cable laying work. Each contract included an arbitration clause providing that all disputes be resolved under the rules of the Hong Kong International Arbitration Center and it designated Hong Kong as the seat. The governing law of both contracts was Hong Kong law. The claimant initially commenced 1 arbitration against each respondent under the 2013 HKIAC administrative arbitration rules, and both arbitrations were subsequently consolidated based on all parties' agreement. The claimant requested the tribunal to declare that its works under the subcontracts were complete and to update the contract price. The respondents contested that and the counterclaim damages for the alleged delay of the claimant's works. A sole arbitrator was later designated jointly by the parties to determine the dispute. The arbitrator was later confirmed by HKIAC under the HKIAC administrative arbitration rules. The tribunal subsequently issued 2 partial awards. The first partial award decided that the claimant was liable for any failure to achieve the required depth at which the cable was to be laid. And the second partial award determined the remaining issues in the arbitration, including the certain milestone payments and quantum issues. The second case related to the repayment of a loan arising out of investment by a Chinese SOE in 3 oil blocks located offshore an African state pursuant to a loan agreement and the shareholder loan agreement. The claimant, a Cayman entity of a Chinese SOE, was a lender under each of the agreements. It commenced 2 separate arbitrations, one under each agreement, pursuant to the 1976 UNCITRAL rules and the 2005 HKIAC procedures. The respondents were the borrowers and the guarantors under each agreement, and they included the National Oil and Gas Company of the African state, a company incorporated in Hong Kong, and the Cayman SPV, as well as the joint ventures for all the 3 blocks. Each of the agreements provided for arbitration under the UNCITRAL arbitration rules, with HKIAC as the administering body and Hong Kong as the seat, and each agreement was governed by Hong Kong law. The loan provided by the claimant was part of a series of transactions entered into by the claimant, and the transaction was structured in a way that the loan will be repaid from the revenues of the blocks. The claimant alleged that no economically viable discovery was found by two of the blocks, and considered that a commercial failure of the two blocks constituted an event of default under the agreement, and requested repayment of a total of $1.4 billion under the agreements. The respondents deny their obligation to repay the loan. Their case was that the alleged commercial failures of the two blocks could not constitute an event of default under the agreement because the geographical conditions, commercial viability, and the exploration risks of the two blocks were foreseeable at the time when the contract was entered into. HKIAC appointed the same sole arbitrator in each arbitration pursuant to the lease procedure under the HKIAC rules. The claimant initially sought consolidation of the two arbitrations, but later withdrew its request for consolidation and also its claims under the shareholder loan agreement, leaving the other arbitration to proceed under the loan agreement. And the parties subsequently agreed to terminate some of the claims in the other arbitration. The remaining claim has been suspended pending the parties' settlement discussions. On this final slide, I have set out some points for you to take away from this presentation. As shown in the cases and the statistics presented earlier, disputes with BRI elements often involve multiple parties, multiple contracts, and sometimes even multiple legal systems. They may feature the direct or indirect involvement of a Chinese SOE as an investor or contractor. Such disputes can be highly complex, technical, or capital intensive. Some of them may even involve national interests and can be politically sensitive. The two case studies I presented earlier show that transactions can go wrong at any stage of the project. Based on our review of HKIAC cases with BRI connections, the common claims are contractual debt claims in respect of services provided for or money invested, as well as damages for breach of contract. The common defenses included jurisdictional challenges, the validity of the underlying contract, breach of warranties and representations, defects or delays in the services provided, and the wrongful construction of contractual terms. It is noted that the parties to some of the disputes also sought to invoke various procedure mechanisms under the HKIAC rules to streamline the process, such as the expedited procedure and the consolidation. If applicable, those mechanisms can actually bring significant benefits to the procedure management of the case in terms of time and cost efficiency. A central aspect to the management of legal risks and disputes is the choice of appropriate and effective dispute resolution mechanism and forum. This is to ensure that disputes are resolved under a neutral, fair, and efficient framework with decisions rendered by individuals with relevant expertise, and their decisions are enforceable in the relevant BRI jurisdictions. In our experience, international arbitration is considered as a preferred method of dispute resolution for BRI projects, and Hong Kong HKIAC also stand out as an attractive option for BRI disputes, given their proven record of experience for handling cross-border disputes involving Chinese parties and a strong record enforcement of arbitral awards in mainland China. The recent entry into force of the arrangement or interim measures has reinforced the position of Hong Kong and HKIAC as a preferred venue for BRI disputes. And when selecting appropriate dispute resolution option in the forum, parties should be aware of the benefits and the risks of each option and makes the most appropriate choice as part of their overall risk management strategy for BRI projects. I will now conclude my presentation and hand over to Maria. Thank you very much.
Thank you, Joe. This is my name is Maria Peterson, and I want to thank you to my fellow speakers. I have been invited to add a somewhat different perspective to the Belt and Road Dialogue, and that of a transactional practitioner. I've also been asked to talk about the challenges that Belt and Road projects are facing today. And there is no question that we are living in unprecedented times, and that the COVID-19 pandemic is having and will have long-lasting consequences on the BRI initiative and the projects as they stand today. Some statistics, according to the Director General of the PRC Foreign Ministry, as of June 19, 2020, about 20% of projects under the BRI have been seriously affected by the pandemic. 40% have been adversely affected, and a further 30 to 40% have been somewhat affected. Meanwhile, experts project the global economy to shrink by as much as 3% in 2020. And in the first quarter of 2020, China's GDP declined by 6.8% year on year, its first recorded economic contraction in decades. There's no doubt that these macro factors are having an impact on the BRI initiative. Many BRI projects have been halted by the pandemic. For example, the China-Pakistan Economic Corridor, Cambodia's Sihanoukville Special Economic Zone, Jakarta-Bandung High-Speed Rail project in Indonesia, and Nigeria's 1.5 billion rail project. In addition, there have been major disruptions to supply chains around the world, and Chinese supplies and equipment imports along the BRI routes have slowed to a trickle. The unevenness of lockdown measures add a further complication, and unfortunately, the end of the pandemic is highly uncertain. So from the perspective of a transactional practitioner advising the different players in the BRI cycle, there are a number of risks to manage going forward, a number of risks to mitigate looking backwards. Now, from the perspective of a transactional lawyer, we look at trying to manage three categories of risks in our documentation in very broad terms. Those are political, financial, and execution. How we manage those risks depends on where we sit on the BRI project cycle. The BRI initiative involves a wide variety of projects, quite complicated, involving multiple players at different stages. So whether we represent a concessionaire, a financier, an EPC contractor or subcontractor, project sponsor, they will all impact our perspective on negotiating and drafting the transactional documents. So, given these three categories of risks, as I said, political, financial, and execution, today's climate actually is almost a litmus test for transactional lawyers in how well we anticipated the possibility of these risks. And I have to say, I'm sure a number of us believe we've fallen short or are congratulating ourselves that our more paranoid instincts have actually proven to be valid. But some of the political risks that we're facing today is that the PRC government, for example, is facing two competing priorities. They need to support the BRI as a fundamental part of PRC's ambitious foreign policy agenda, yet they need to focus on the domestic development issues exposed by the pandemic. Similarly, in the Belt and Road host countries, we are dealing with a number of unstable government structures, dramatic policy changes or regime changes, which have a direct impact on the approach to the BRI projects. And these changing political dynamics, both in China and the Belt and Road countries, create risks. So how do we mitigate them? And as I said, today's dynamics create a lesson for future projects, but also challenges in how to mitigate existing projects. Some of the risks we deal with, a large percentage of the risks we deal with are funding and financing risks. The funding shortfalls for multiple Belt and Road projects are significant. The Chinese policy banks are under pressure. Yet demand will continue to grow for infrastructure in Eurasia and Africa, coupled with real limitations on the available resources for the recipient countries. Many countries have been asking China for debt repayment freezes or debt cancellations. Additional requests have been made by countries for concessions in respect of debt relief, including the easing of debt obligations. This type of dynamic has all the players suddenly looking closely at their agreements, their funding and security agreements, and the clauses which may afford them flexibility or relief. Financial restructuring is a likely scenario for many of these projects, and we're now looking at debt covenants, security packages, guarantees, bond terms, and frankly, whether commercial restructurings are going to be necessary. On the operational side, a number of the ongoing projects may need to be rescheduled or even abandoned due to delays and the lack of funding caused by COVID-19. Parties will continue to seek to rely on contractual provisions to avoid or delay the performance of their obligations. Meanwhile, there's also going to be a shift. We anticipate a shift to projects relating to energy or pandemic management that may lead infrastructure projects cash-strapped or at least lower in terms of priority. And the financial constraints the parties are facing now could lead to a shift in the pursuit of quality versus quantity in future BRI projects. EPC contractors and subcontractors are particularly affected by these operational risks. Their business models and performance are impacted by the uncertain outlook. And again, people are reviewing the different agreements to see what are my options. And in terms of trying to manage these risks as a transactional practitioner, we need to navigate a very uneven set and inconsistent legal regime dynamic. Because as we know, BRI projects involve many different legal regimes and often an unevenness in terms of levels of maturity. The host country regimes can be quite immature, whereas the governing law provisions, if they're not the host country, would come from a more mature jurisdiction, such as the UK. Funding documents may be governed by laws different from the project documents. And these inconsistencies in regulatory regime will be of some concern now for the commercial parties, because as we seek to analyze and invoke potential avenues for relief, we will be doing that in the context of inconsistent legal regimes and unfamiliar courts and unfamiliar levels of jurisdiction. So given this very challenging landscape, I wanted to just look at a few of the clauses that people will be reviewing now in their various contracts. And these are clauses that, contractual provisions that are generally negotiated to afford some flexibility in the event of these types of crises. And again, how well they hold up today is really a litmus test for many of us. Everyone is certainly looking at their agreements as we speak to see on what basis they can have to mitigate the risk they're facing. One very classic provision that is probably being read all around the world and has been read all around the world since March is the force majeure provisions. And the force majeure clauses, as many practitioners know, tend to just be dropped in. They tend to be boilerplate provisions that are taken from other agreements or other precedent and tend to be dropped into an agreement during the context of negotiation without much thought. I imagine that these provisions are being parsed to a level of detail that's probably unprecedented in the last several years. So force majeure clauses are generally, force majeure is generally defined in the contract as an event or circumstance beyond a party's control, and that cannot be overcome through a party's reasonable efforts. And the force majeure provision generally contains a non-exhaustive list of events that constitute force majeure. One issue is whether or not the scope covers pandemics or COVID-19. Obviously, that will vary from case to case. Now, it's important to note when we're doing these contracts that there is no general right to force majeure clauses, that we need to specify the consequences of the force majeure, whether it can give rise to a temporary suspension or a right to terminate. We need to look at the causation aspect of the force majeure clause. And then very importantly, the notice requirements, because force majeure declarations require very strict notice provisions. And here we go into the impact of the different regulatory regimes, because force majeure is not created equal across different legal systems. Another example is the change of law clause. And these change of law clauses are usually included to provide some relief for the concessionaire in the event of a change of law for the host country. The host countries today may be enacting policies and regulations designed to mitigate the impact on them of onerous obligations under these projects, and parties sitting on the other side will be reviewing the change of law to see what kind of relief they can claim. We have to look for those clauses. We look at the triggering change, the scope of the type of change of law that would trigger the relief, the type of relief we'd be looking for, whether that is compensation for increased costs or giving us additional time to perform our obligations, and whether expenses actually need to be incurred already. Practical steps that parties should consider is whether the change of law may already be covered in the force majeure clause, and whether how those two clauses interact. Another provision that has been the subject of much legal discussion in the context of projects and COVID-19 is the material adverse change or material adverse effect clauses. And here the key issue is what constitutes a MAC. Very often, the MAC will not necessarily cover a pandemic result, or it will be very specific as to the nature of the event. So reviewing these clauses and preparing these clauses will now take on a different stance given what we've seen in the last several months. If there is no general right to claim a material adverse effect, it must be agreed within the terms of a contract. So again, the definition and the scope of the MAC is key. But also important to note that the MAC clause will be interpreted in the context of the entire agreement and in conjunction with evidence of the party's intent. Further, the MAC needs to be of a sufficient magnitude that it is actually material, and it should generally be of significant duration. Another aspect of the MAC clause is the causal link between the change and the MAC event. A party will generally need to show that the change it relied on has caused the event, the damages it's claiming, or the relief it's seeking. Right now, and this is in active discussions, active negotiations I'm involved in, the MAC definition is probably one of the most actively discussed negotiated provisions. And to what extent pandemic events can be excluded, should be included, and what type of relief can be negotiated. Another type of clause, and I recognize that I'm running out of time here, so I'll try to run through these quickly, is the renegotiation clauses. Some contracts have specific clauses that allow for the renegotiation of certain key terms, such as the price or the volume of goods or other contractual performance rights. Whether the COVID-19 outbreak will have triggered such rights to negotiate will, of course, depend on the specific terms of the contract. And finally, we look at the termination provisions because a number of parties may be seeking an out. The commercial dynamics that led to the agreements may no longer be applicable. And the termination provisions will be very important in determining the options of parties can claim. So what is the scope of the termination rights? Who is covered? Who bears the greatest risk? In preparing these agreements, the practitioner really needs to focus on where we stand. What is our risk? And to cover for that. And parties may end up invoking the termination clause now simply as a fallback in the event the force majeure agreements don't apply, or using termination as a form of leverage to negotiate a commercial solution. Again, the wording, the scope, the precision of these clauses has never been more important. In conclusion, I'll say that there will be no end to the creativity that we have seen and we will continue to see in terms of contract interpretation to find support for the relief or flexibility that parties will be seeking given the very challenging circumstances in the Belt and Road today. And for the practitioner, the transactional practitioner, that means a much more serious look and focus on clauses that frankly have not always been the target of as much attention as they need to be today. And that concludes my perspective from the transactional lawyer, and happy to answer any questions. Thank you.
Thank you very much, Maria, for your informative presentation from a transactional lawyer's perspective. And now I have already seen a few questions that have been sent through. The first question I would like to address that to Professor Kidani, which is that you mentioned earlier the different dispute resolution options for BRI disputes. You talked about conciliation, mediation, arbitration. You also talked about the China International Commercial Court. What is your advice in terms of which of these, how to choose these options for BRI projects?
Thanks, Joe. It's situation dependent, and obviously before a dispute escalates to a binding form of dispute resolution, almost every standard contract contains negotiations, and then if that doesn't succeed, you escalate it to mediation or conciliation. And in China, conciliation, I know historically has been an extremely important means of dispute resolution. So if all of those amicable forms of dispute resolution do not succeed, obviously some percentage of disputes would inevitably escalate to a binding form of dispute resolution. Now, if everything happens within the same jurisdiction, then the likelihood that the courts may be able to resolve it increases, although some might choose an alternative dispute resolution, domestic arbitration. But certainly if it's of a transnational nature, because of all the jurisdictional complications and the cultural complications, all of those things, obviously international arbitration has been the chosen means of dispute resolution, and that has happened over the last several decades. It's grown in importance, and primarily because of the enforceability of these awards across international borders because of the New York Convention. So although it is situation dependent, and we can at this point say that arbitration obviously has become the principal form of dispute resolution in transnational commerce and in transnational investment. So that would be, and in terms of the newly emerging commercial courts, whether in Singapore and China, the CICC, they are in the process of developing, and they have their own advantages, disadvantages. But obviously, it's something that we need to wait and see in the coming years, how well they do and how well they'll be received by the business community. So I'll stop there. Thank you.
Thank you very much. The second question is for Maria. Could you please present or explain a case where MAC, i.e. Material Adverse Change, was adopted, and an opposite case where MAC was not adopted? Under what grounds were these cases adopted or not? Thank you.
In terms of general versus specific cases, because it's really very kind of, I'd say, transaction specific. A party will try to negotiate an MAE clause as an exception to performance, to say, if an MAE event occurs, I am excused from this type of performance, or this meeting these specific performance standards, and or I have the right to suspend performance. And that is where the scope of the MAE is really important, because a general MAE will just create more, I would say, more disputes among parties. And the precision, so taking a shortcut in the negotiating process will actually lead to more pain in the implementation process. So without an MAE, then you argue, you'll have to look for different grounds. If you're the party seeking relief, or vice versa, if you're the party seeking performance, seeking to enforce performance. The MAE is almost like a pre-agreement as to how hard do we have to try, and when do circumstances beyond our control, and I won't even say that in the force majeure provision, excuse us from these standards. So again, having a precise and specific MAE discussion is, I think, an important tactic for parties to enter into a smoother implementation relationship.
Okay, thank you, Maria. The next question I wanted to pose that to Professor Kidani, which is that how do you distinguish in dealing with a BRI contract dispute and a dispute involving parties which happen to be located in a BRI country?
So Joe, if you could please.
Yeah, I can repeat that.
Yes, please.
So how do you distinguish in dealing with the BRI contract dispute and a dispute involving parties which simply happen to be located in a BRI country? Okay,
so I now understand the question. If it's a BRI, now the classification of projects as being BRI or non-BRI may have certain difficulties. It may become increasingly clear, but you need to look at whether it's a part of the broader BRI financing mechanism, and now I call it a framework going forward, or it's outside of that. Obviously, Chinese companies and Chinese state-owned enterprises do business across the world, and some of those projects happen to be within the BRI region, as it is exemplified in those maps that we showed earlier. So not everything that happens within that geographic scope is BRI related. There are projects that have actually predated BRI in terms of its own policy pronouncements and are still going on, whether in the form of project execution or operation of those projects. So you need to look at each individual project and try to link it. I think the best way to determine might be to actually follow the stream of financing and see if, from a policy perspective, that is a fund that is allocated for BRI project. That might actually sometimes be very difficult because of the multiplicity of players now, but it could be, so that might be a good way of telling whether it is actually a BRI project or it's a non-BRI project. But now increasingly within that region, within that BRI belt and road, I think most projects now are being increasingly classified as BRI related. And even when they are not BRI related, there is this influence that because of its massive scale of the mechanisms of dispute resolution, the choice of law, and all of those things are actually contributing to this normative shift, as I said at the beginning of my presentation. So it is basically engulfing almost everything, and it's now the new Leviathan. But we will see how it goes, but that would be my response to that question.
Thank you very much, Professor Kidani. And there's a last question for me, which is that, may I ask, are these high-profile disputes you presented investment project related or M&A related? So the two case studies I just talked about were both project related. The first case was about the laying of subsea cables in the Middle East. And the second case was investment and also project related, was about the financing of the exploration of oil fields in Africa. It was investment made by a Chinese SOE through 2 loan agreements in relation to 3 oil blocks. In my preparation for this presentation, I did identify a corporate dispute, although that was not M&A related. It was about a dispute, a shareholders dispute between a PRC company and also a Malaysian company. The underlying project was the development of infrastructure in a special economic zone of a Southeast Asian state. The claimant, i.e. the Malaysian company, sought to terminate the contract and also the return of certain equity of the joint venture of the project from the Chinese company, which was triggered by the alleged breach of the contract and the alleged failure to complete construction work by the Chinese company. So that was not an M&A dispute, but it was a corporate dispute arising out of a shareholders agreement between a Malaysian and a PRC company, which also had a strong BRI connections. And I think in the interest of time, we have to end here. Thank you very much for the questions. For those we haven't had a chance to address them, we'll try to answer those questions by email. And also we will send the slides of the presentations today to all the attendees of this webinar after this event. It remains for me to thank all the speakers for taking your time to contribute to the discussion today. And also I would like to thank all the attendees for participating in today's webinar. We will have more webinars coming up in the next in the coming weeks, and we'll make announcement of those webinars that we will circulate the information to you in the coming weeks. Thank you again.
Thank you.